something like it before, and I know that people don't necessarily arrive on time. So I'm going to spend a couple of minutes doing my own abbreviated biography. First of all, as those of you who have seen me around, I am Rick Wood. I'm a parent. My son is 20. He'll be 21 in a couple of weeks. Was diagnosed as number 34 when he was 3.5. My very brief background is that I became a lawyer in 1976, and following my obtaining a Juris Doctorate degree, I went back to school for a year and obtained a master's in taxation. And part of my practice is estate planning, and has been for quite a long time. Actually, I just dated myself because that's 40 years. The one thing that I wanted to sort of begin with is that the first special needs trust, and we're going to be talking about those, that I drafted was in 1998 when my son was 3 years old. And the reason that I drafted that was obvious. It is because I figured that he needed one. Interestingly enough, when I was in law school in the 70s, special needs trust was really not even a concept. And so when I drafted that trust in 1998, I didn't have any guidelines, I didn't have any volumes, I didn't have very much in the way of literature because they were new or they were almost non-existent. And so I sort of devised my own based upon what I saw as an opportunity and what I knew of the code, the Internal Revenue Code, as well as regulations. Well, since then, that of course was 18 years ago, the area has come along quite a long way, and I attribute that to the increase in the number of diagnosed autism cases. In other words, the population that could benefit from this has expanded dramatically in the last 20 years. And so now we've got a whole lot of people who write about this stuff, and there are practitioners' guides, and there are forms and samples and so on. The reason I tell all of you this is that what I'm going to say at the end is that you need to see a lawyer with estate planning experience in order to get the things done that I'm going to talk about, and specifically a lawyer with special needs trust experience. He or she doesn't have to have a lot of it, but has to be familiar with it because it's a very complex area of the law, and it needs to be done right. And if it's not done right and it's wrong, then your estate or your child's estate is going to be at risk, as well as your child's income if he or she receives income, which is basically SSI once reaching the age of 18. So that's sort of the introduction and how I sort of got here on my own, and we're going to, as people continue to come in, we're going to, they missed the intro, but we're going to dive in. Let me ask before I start, how many first-timers? Okay. How many people have seen some version of my presentation before? Oh my, okay. Well, for those of you who've seen it before, there's some stuff that's new, but there's also stuff that's old. And what I really want you guys to focus on is not necessarily the details, although I will take questions as you present them, but the conceptual framework in which estate planning, when you have a special needs child, is appropriate. I'm speaking to people from 50 states and more than one country. I'm from California. Special needs trusts are driven by the Internal Revenue Code, which is a federal statute and applicable to all states, but a lot of other things are different, and the way that the states dole out money and provide entitlements and benefits is different in each instance. So enough of that. So this first session, and by the way, this used to be one session, and they gave me about an hour or maybe an hour and 15 minutes or so, and this time they said it's just not going to be able to be done. There's more stuff to talk about. There's new stuff to talk about. So now we have 2 hours, and we'll try to get through what I want to get through in this first hour. So this first hour is, what happens when the parents are gone? Well, frankly, you have to plan now for when you're gone, because we're going to be gone. And what I didn't know all those years ago when Davis was diagnosed is whether I would outlive him or whether he would outlive me. And what we know empirically now is that the rule is that these kids are going to outlive us, that we're going to go first. So in order to protect them after we're gone, we need to do some planning now. And so, introduction. Basically, I hate to be so crass about it, but we're protecting money. We're protecting income, and we're protecting assets. I've attended a very poignant session this morning, moms talking about placing their children, housing options, and so on. And I was thinking to myself, boy, mine's really stark because all I'm talking about is the money. But we have to have the money in order for our children to survive after we're gone. So there's a couple of different types of benefits: entitlement public benefits and needs-based public benefits. Both of those are money. Well, entitlement benefits are Social Security retirement for those of us who work and get the number of working quarters in, are entitled to Social Security. At the bottom, you see Medicare. Everybody's entitled to Medicare at 65 in this country. Social Security disability insurance, that is a program that is really for people who work and is not applicable to our kids because they're not going to work. They're not going to get the required work experience and then become disabled. They're already disabled before they start working, so it's not a program that is available to them. And then we have Social Security survivor benefits, and those survivor benefits relate to when you pass away and the child is under the age of 18. There are federal programs in the United States for those of us who are here in the United States that are available for children. All right, needs-based. This is where the action is for us. First of all, supplemental security income is called SSI. How many have kids over the age of 18? How many are receiving SSI? All right, so here's how it works. When you turn 18 and your child doesn't work, which of course is our kids, you're entitled to SSI, which is not Social Security, it's supplemental security income. It's quite modest, but nonetheless, it's automatic. However, the child can't have any assets, and he or she can't have any income. To the extent that there is income, it gets deducted from the benefit that is otherwise available to the child. Second is Medicaid, and those of us who are not from California know that it's the health insurance program that is available for those who can't afford health insurance. All of our kids will qualify because at the age of 18, they're not looking to the parents' income in order to qualify. They're looking to their own income. In California, it's called Medi-Cal, but it's the same thing. The third category of needs-based benefits is government housing assistance. We think of that as Section 8. Section 8 is this program where basically the government gives you money to pay rent. Again, you have to qualify by not having very much income. The problem is it's just a broken system. It's a broken program because it is swamped and has been for decades with more applicants than there are funds available or than there is housing available. And you have to have both. You've got to have money and you've got to have qualifying housing, and that varies from state to state and community to community. So we're not going to spend a whole lot of time on government housing assistance because you get on a waiting list and it might be a couple of decades before you actually qualify. Sir. So the question is, if you have a second residence, parent has a second residence, can the child rent from the parent and qualify for Section 8 housing? And the short answer is yes. You get on it doesn't matter who owns the residence. I'm going to talk about something in the next session that is coming nationally, is coming to this country and is in California now, self-determination, that allows for that to happen in a different way. But the problem with Section 8 is that you've got to the owner can't make any money, which is fine in our instance if you have a second home. Most of us, however, don't have second homes, and it's not an option that's available to us. And then finally is IHSS. Anybody familiar with that acronym, IHSS? Okay, there we go. So this is a program that varies from state to state and may be called something different in states other than California, that essentially pays a parent who needs to stay home to take care of a child. The pay is really lousy. It's minimum wage, which in California is $10. I think federally it's still $7.25. And so the reason I put that up on the board is that I think it's really important for you to go to your Department of Developmental Services or the equivalent and say, hey, I hear about this program called IHSS. This is not an unfamiliar term in most states. Is there an opportunity for me, or can I qualify to be paid to care for my child because I've had to quit work, or I would otherwise have to pay somebody to care for my child? And I'm not suggesting that the parent has to be, should be, or wants to be the caregiver. I'm simply suggesting that, remember, we're talking about money, that there are opportunities for you to make up lost income and have you continue to care for your child. Okay. We're going to talk really briefly about SSI. It's to provide income for subsistence level food, shelter, medical, and attendant care needs for adults with disabilities who have little or no income and assets. Okay, now those of you who don't have an adult, this is still important. And the reason for that is, you're going to see later that you do not want to accumulate assets for that child, or you're not going to qualify for this income. That's the reason why you need to think about planning today instead of when he or she attains age 18. It is not retirement, and it is not disability insurance, as I explained earlier. The amount of benefit is based upon the income of the adult child, and the maximum federal benefit is $721. There's a formula, and I'll never understand it, but they attribute some income to your child if your child is living in your home by asking you, well, how much is your mortgage payment, and how much is your rent? I don't know how the formula works. They figure it out, and it is what it is. And for us, it goes up a few dollars every year, and then goes down a few dollars every year. But basically, it's somewhere between $600 and $700, I think, for most people. Now, by the way, this is what the government thinks an adult with disabilities can live on. That's it. So you can see that it's a limited program. All right, and that, by the way, is why we're going to talk about some planning so that we can have our children live on something other than limited income. Income includes earnings, unearned income, which is Social Security benefits, pensions, unemployment compensation, interest income, gifts, cash, fair rental value of shelter. That's where they get most people, and deemed income of either spouse or parents. Again, a child who's aged 18 or above is not subject to the deemed income rules. Finally, SSI for kids is based upon parents' income. So what did I say earlier? I said, well, when you become an adult, you're eligible for these funds. Well, that's actually not true. But the problem is that if you're under age 18 and you otherwise qualify because of a disability, you look at the parent's income, and most parents have enough income for the child not to qualify, so it's almost non-existent. All right? Medicaid. Medicaid is low-cost health insurance. It's funded by the government. It's free. Our kids qualify for Medicaid. It is not income-based. Now, most of us who have income will never qualify for Medicaid because we have too much income. You can't have much income. You can't have assets over $2,000 in value. So as a practical matter, we don't have to wait until age 18. So what we did in my instance is that I have a health insurance plan through my business. And my child, as a dependent, of course, is a participant in that plan and obviously eligible for the insurance coverage that we purchase. In addition to that, we have Medicaid. In California, it's called Medi-Cal. Now, I did not figure this out until he was about 4 years old. And I have to tell you, for the first 4 years, I mean, I'm a lawyer. I didn't know any of this stuff. For the first 4 years, I had like a second mortgage payment because of the medical costs, and he had a lot of needs in those first 4 years, and we just paid and paid and paid, and finally somebody from the local social services department came to me and said, you know, you qualify for Medi-Cal. I said, no, that can't possibly be, we make too much money. No, he qualifies for Medi-Cal because of his disability. Medi-Cal and Medicaid are the same thing, and so if you have insurance, go get a second coverage. Why? Because if you have that second coverage, you're out of pocket, meaning your deductible and copay is covered by that second insurance policy. And so the important thing is that you not put any money out of pocket. So since the age of 4, my son, all of the things that have gone wrong, and they go wrong regularly like all of us, has not cost us any money. Why? Because money's available. You just have got to tap into it. Okay, the last section is this thing called transfers of property to special needs trust. I'm going to talk about that in just a second. We want to get rid of a child's assets. That's the fundamental concept of planning. 1, preserve need-based benefits, that's income. 2, provide additional financial support beyond benefits, so if that $721 is not enough, which it never is, there's a device that is available for you to provide additional financial support, not to supplant or replace, but to supplement the income that the child receives from the government. 3rd, preserve assets for other heirs on the death of a special needs beneficiary. That's the principal function of a special needs trust. And then finally, coordinate with the rest of the family's planning. So, why do you need an estate plan? I got to tell you, if you own a house, if you have any equity in that house, I realize a few years ago none of us did, but there's equity again. If you have life insurance, if you have other assets, and you don't want them to go into the hands of somebody who has special needs and then be taken by the government in order for that person to qualify for benefits, you got to get yourself an estate plan, and that includes, at the beginning, a living trust. That provides an orderly distribution of the estate. You, in a plan, appoint people as the holders of powers of attorney for health care as well as financial decisions during your lifetimes in the event that you become incompetent and unable to actually make decisions. And obviously the foundation is a living trust. It avoids probate, unifies distribution of assets, provides for beneficiaries beyond the age of majority, and saves estate taxes. And let me go to that second to last point. Providing for beneficiaries beyond the age of majority. So here's how I say it to my clients. Let's just assume, I'm going to just pick a number of $50,000. $50,000 is a pile of money, but it's a big pile of money for somebody who's 18. And my experience is you give an 18-year-old $50,000 and it's probably going to have some kind of a bad result. Either it's going to be gone or it's going to have collateral effects on a person's life. What a trust allows you to do is defer distribution beyond the age of 18. If you don't have a trust and you only have a will and you've got a child who's 16 and you die and he or she ages up to 18 and receives that $50,000, that person is on his or her own. And so there are many, many trusts which delay or defer distribution of the assets to an age or upon the happening of an event that's later than the age of 18. And so, and this is applicable to everybody, whether you have a special needs trust or not. All right. Before we get into the special needs trust, this was not in my last session a couple of years ago, but I really come to endorse this thing called a memorandum or letter of intent. And, you know, the last session that I was in, one of the presenters was describing what I think she called a care notebook that she provided for her caretakers. And I thought to myself, and my wife Cheryl and I were talking about this, we have instructions for caregivers and so on, but it's not as complete as it ought to be. Here's what a memorandum of intent does. It describes your child to whomever is going to be left behind to manage your estate, to administer your estate, and also to make decisions regarding his or her care and placement. Who knows our kids better than we? No one. Of course we know our kids the best. The great thing about a letter of intent is that it's not something where you have to go to a lawyer and update at an expense. It's just a letter. It goes into your estate plan notebook or at the front of your documents. It's handwritten. You can date it. You can amend it. You can add to it. If there's any question about whether it's really your intent, you can sign it. And what it does is it gives direction to those who need it the most. For most of us, our typical children will age up, they will go on and they will have jobs and they will get married and have children and do whatever they do, but they've got the capacity to carry on their lives. But our kids don't. And so this thing in my mind, and over the years I've thought a lot about this, and years ago it just wasn't something that I had focused on, but I happened to do a plan for somebody who owned a radio station and had owned it for many years, and this had nothing to do with special needs, but she wanted to leave a legacy, and she had ovarian cancer. She knew it was terminal. She was going to pass, and she said, well, I really want to tell the people who I leave behind what I want. And we devised a plan that kept this radio station going for a long period of time because that's what she wanted. She worked on it for 30 years and wanted it to continue. And I said, that's easy. You're a writer. She actually had a newspaper, a television show as well, and she was the principal writer. And I said, you're a writer. Write your instructions. It can be a page and it can be a book. It doesn't matter. But you need to tell people what it is that you're thinking. And if you look back on that every once in a while, maybe your thinking changes. In fact, it probably will change because circumstances change and your kids age up and so on. So irrespective of whether a special needs trust is something that is developed by you, this is a great thing to have. And so we have created one, and we keep adding to it. And as things go on, and more information we think that there is that we need to impart. I mean, it could be as simple as telling somebody what the medication regimen is. It's that simple. Who would know what the medication regimen is unless that person is absolutely intimately familiar with that in the event that you came out here and were run over by a car? So, and that can be changed without having to go to a lawyer and change your trust. All right, here we go. Okay, a special needs trust, there are a couple of types, we're going to get into them, is nothing more than a mini trust or a piece of an overall estate plan that's either embodied in a living trust or is a standalone document. So let me just kind of tell you what it is we're trying to accomplish. We provide for the person, the special needs person, during his or her lifetime. In other words, the trust lasts as long as the child is alive, which we're going to assume is longer than we're alive. Second, it preserves the estate for other beneficiaries. And what I mean by that, it gets right back to that idea of benefits. We want to make sure, if we have more than one child, that the special, well, maybe not everybody, but I think most people want to make sure that the other kids aren't left out. After all, they're our children as well. And if we've got anything left, we want to take a piece of our estate, give it to those other kids in one form or another, and then hold whatever it is that you think is going to be necessary or appropriate for your special needs child to last for the rest of his or her life. It ensures continued public benefits without invading principle. Okay, this is the most important thing about an SNT, and that is that if there's a special needs trust that supplements the SSI, remember that $721 a month? If there's a special needs trust and it has principal or income that is to be used to pay for food, shelter, care provision, virtually anything related to having a comfortable life, you can leave that in trust, and the income from that trust is not going to disqualify the person from receiving government benefits. And that basically summarizes it. The income from the trust and the assets don't count. And so you can still get public benefits. $700 a month is $8,400 a year. If the person is 20 years old and lives to 80, that's 60 years with inflation, cost of living adjustments. That's a pile of money that you want to be able to protect. All right. And then finally, it eliminates the reimbursement of government benefits paid. Now, we're going to talk about one of two types of SNTs that actually the government can get its clutches on in the event of the death of the beneficiary before it's distributed to someone else, and that is to reimburse the government for medical or Medi-Cal or Medicaid benefits actually paid. So in a typical special needs trust that we're going to talk about, the government can't get its hands on the principle of the trust. And so the way it works in a conceptual way is, let's say you have 3 kids. Let's say you want to divide your estate 3 ways. You want to provide enough money for your disabled child to live without burdening financially the other 2 kids, because after all, who's it going to fall on? And so you take the 2/3, you distribute it to the kids, either now or later, depending upon their ages. With respect to the third part, as I mentioned, it's this pot of money or assets that is in this trust, and you use that to pay for medical if you need to, or you use that to pay for food, shelter, clothing, daycare, and the like. If there's something left over, the trust doesn't have to repay Medicaid or Medi-Cal in California for that which has been provided over the years to your child. So what happens? Where does that pot of money go? It goes to the other kids. So you're preserving, in the event of the passing of your disabled child, you're preserving your estate, that portion of your estate that belonged to him or her, to the other 2 kids. Okay, there's 2. First party SNT is established during the lifetime of a person with disabilities. And let me tell you how that actually works. In a non-disability situation, it works when somebody, for example, is injured in a car crash. Think about that, very, very common. Well, I mean, it's not so common, but common example. And that person is under the age of 18. Or that person could be an adult. And so let's assume that there's a settlement, and the settlement is $100,000. We just use that number. The question is, has that person become disabled as a result of that crash? If the answer is yes, and in our instance, we meet the criteria, because we don't have to have a car crash for that to happen, but in the event that the person is disabled, that person will qualify for an opportunity to take that $100,000 that would otherwise go right into his or her account, and if under the age of 18, it would be a guardianship of the estate that would control that. Over the age of 18, it would be a conservatorship of the estate that would control that. But if you set up an SNT, you don't have a guardianship or a conservative, or at least you don't need it for the $100,000. It just goes in. Or what happens if a grandparent dies and leaves money to the disabled grandchild? Common. Well, we can't have the disabled grandchild have money, because then the disabled grandchild will not qualify for the $721 a month. And so what we do is we take the assets of the person with disabilities and we put it into a trust, and then that is out of that person's control. So it's a lifetime thing. It's created now from assets that exist now. There's an alternative to first-party SNTs called an ABLE account, Achieving a Better Life Act, which was passed in 2014. I'm going to talk about that in the next session. It's a really cool thing that just came into existence about 1.5 years ago, and is a less expensive alternative than a trust. But the concept is the same, and that is you take the assets, wherever they are from, and you put them into a first-party trust, it's there during your lifetime, it's there during the child's lifetime, you pass away, and the child gets to use those just like if that were a trust that was set up as part of your own estate plan. And so what am I trying to accomplish? I'm trying to preserve benefits, whatever they might be. All right. A third-party SNT is the one that I first started out with, and that is a special needs trust that's created by others and funded with others' assets. So in my case, what I set up back in 1998 was a third-party SNT. I have an estate plan. I modified it to include this separate trust for the benefit of my child that essentially says, here's your share. It's exempt from, it won't disqualify you from receiving whatever benefits you're entitled to because it's not part of your assets and its income is not part of your income, and it can be used to supplement this $700 or $600 a month that you are entitled to once you reach the age of 18. It's not a separate plan, it's just a plan within a plan. And this is why if you are going to do some estate planning for special needs children, you should have somebody with experience. Doesn't have to be an expert, but somebody with experience in drafting these things because they're very, very specific to keep them out of the clutches of the government. Another example of a third-party SNT is this. It's very routine in estate planning for life insurance. By the way, I don't sell life insurance, and once I gave I gave a presentation some years ago. It seems to me it was when we were in Greenville. Was it Greenville? Greenville. When we were in South Carolina, they had me co-present with this guy from MetLife, and MetLife does a lot of work in the special needs area, and they're known to be quite good. But this guy was selling life insurance. And I didn't like that because I don't sell anything. However, I'm going to say this about life insurance. You got to have life insurance. It's cheap. Term insurance. It's so cheap. You just got to have it. If you get run over by that truck, what happens to that $100,000 policy? You know, we got a lot of younger people here. It's so cheap per month that you can create an estate for a person with disabilities that, frankly, I think that you owe to your children. And that would be all of them, because if the person who has a disability doesn't have any assets, it's going to fall upon those who are not disabled to care for that child. So let's assume somebody buys a $100,000 life insurance policy. $12 a month. Person dies prematurely. $100,000 goes where? Well, normally you have a beneficiary designation, right? And it says, you know, to my spouse, and if my spouse is not alive, then to my children. Okay, they're very, very common. Well, we don't want to do that because we can't put that $100,000 in the name of the special needs person, because then it'll disqualify him from receiving government benefits. And so we create the third-party trust to receive the proceeds of life insurance, so they never are in that person's estate. They're just available to supplement the government benefits that the person will rely on in order to survive. So I started this by saying, look, I believe in life insurance, even though I don't sell it. But the reality is, oh my gosh, what do you do when you have a life insurance policy and all of a sudden you've got these proceeds that are in that person's estate? Now, there is sort of there's a safety net here. There's an opportunity if somebody were to receive proceeds to actually take those proceeds immediately, and I've done this, and create a first-party SNT. In other words, the first-party SNT can be created at any time during a person's lifetime up to the age of 65. And so, as a practical matter, it's not the end of the world if life insurance proceeds goes to that person, but if you're going to want to protect it eventually from the government anyway, why wouldn't you just create a trust to be the beneficiary or the recipient of those proceeds and not have to have somebody set up a first-party SNT? Okay. Third-party SNT. Oh, there's our service dog. There you go. Obviously not behaving correctly. All right, so I've talked about this. I got a little ahead of myself. Purpose is to save assets on behalf of special needs beneficiaries without disqualifying the beneficiary's eligibility for federal and state aid programs. So I just wrote in a sentence what took me like 10 minutes to articulately say. Second is funded with assets belonging to the settlor, which is parents or grandparents. Third, standalone trust are built into a estate plan, as I mentioned. And 4, it's used obviously for the care of the child and is not considered part of that person's estate. Special needs trusts are not only complex to set up, but nobody has to invent anything, because there's now there's practice guides for lawyers to look to make sure they've got the right language to qualify them under the Internal Revenue Code. As a practical matter, however, when you have a special needs trust and it's administered by somebody, there are responsibilities that a person has, and therefore it may cost more if lawyers are needed afterwards in order to assist in managing the estate. And essentially what it is that there's administration expenses, and you have to account to the beneficiary or beneficiaries every year, and you have to file a tax return separate from your individual tax return, and that costs money. So we're going to talk in the next session about, probably in the next session, because I'm running out of time, I'm sure, about an alternative, and that's what I called an ABLE trust or an ABLE account. But the bottom line is that there's a responsibility that goes along with creating these trusts, and that is for the person who's left behind. So who's going to manage it? Well, more often than not, it's a family member, and that's true in most estate planning. Most parents name a child or children as the trustees, successor trustees of their trust. And so the same would apply for someone who has responsibilities for, or you want to impose responsibilities on for your child. And this is something that's going to last a long time, so you have to have a couple of successors in there, and they shouldn't be older people or people your age. They should be younger people to carry on, because at some point in time, we don't know when, at some point in time, our child with disabilities is going to pass away, just like we will. And if you want to have any say in who that person is who's going to manage that, and management basically consists of 2 things other than the reporting. One is investing appropriately and conservatively in things that produce revenue or income, and distributing appropriately. And the appropriately is for the food, shelter, care, education of the person with disabilities, just like it is for people who are typical. So the concept, as we think about it, is more important than the details. The concept is keep assets out of the hands of your person with disabilities. And the way to do it is what we have described. Okay, really quickly on ABLE accounts, I'm going to talk about these in more detail next hour. So I mentioned in 2014 that Congress passed this act, and basically it says, okay, if you want to create what Congress thinks is a small estate, which is assets up to $102,000, and exempt those assets from being considered when a person with disabilities is applying for and receiving benefits, you can set up an ABLE account, and it's under 529 of the Internal Revenue Code. And some of you may have heard of 529 because that was an act that was passed about, 10 or 15 years ago for education, where you put money, after-tax dollars, into an account, and the account grows tax-free, and the distributions for tuition and room and board at college and books and so on are not subject to taxation. They've become very popular and an important planning tool for people. And so somebody came up with the idea, and I don't know who sponsored this bill or who created it and then who sponsored it or co-sponsored it, but somebody came up with the idea, well, why don't we create something for those with special needs? And as you can see, it's the same concept. It's 529A of the Internal Revenue Code. So what Congress did is they said, okay, we're going to leave it to the states to set these things up. Federal government is going to manage this. We're just providing the opportunity for the states to establish them. Well, hardly anybody got on board, and I'll tell you that Florida was maybe the first, if not one of the first, to create or establish these as an opportunity. And so because the other states were so slow in coming to this, in December of 2015, just 7 months ago, Congress passed a law, an act, that said, beginning January 2016, you don't have to live in the state in order to set up a state 529 plan. And that's very similar to this education plan. You don't necessarily have to live in the state in which the plan is actually established. And that's a really good thing because it's essentially opened it up to the entire country. And so what's going to happen here soon is that the financial institutions are going to get their hands on this, as they have on the 529A education accounts, and they're going to be recommending that people set these up because it's just a brokerage account. You can invest in stocks, and you can invest in cash, you can invest in annuity, or whatever it is that you want to invest in. After-tax dollars goes in, and the contributions can't be more than $14,000 a year. So you know, a grandparent, for example, can say, oh, you've got one of those. I'm going to put $2,000 into your account. A parent can do it. A friend can do it. Anyone can do it. And the idea is that there's no cost. There's no administration fees other than whatever the brokerage is charging to administer it. And as we know, brokerages are charging less and less and less because it's become so much more competitive. So the question was, or the comment was, it may not be as flexible as we have stated because, as I have stated, because you are limited to the investments that you can actually put in. Frankly, I don't disagree, but for most people, the investments that are available are going to be, are going to be conservative enough. So the comment is that somebody in another state may not receive the same tax benefit, state tax deduction that otherwise would be received. But here's my view on that. It's like this is a new program, and it's going to ultimately, I think, respond to the needs. I mean, what's happened in the world of disabilities, and you know, I do a whole lot of advocacy on the California level. There's 300,000 people with developmental disabilities in the state of California. The state spends $5 billion a year on providing services to those 300,000. It's all about autism because of the explosion in the number of cases of diagnosed autism, and so the ranks of the disabled have come up, and I think the market is going to ultimately persuade Congress to do what's necessary in order to make these things as an alternative available. And but we're new. We're really new on this because it's only a law that's a year and a half old, and then with the cross-state participation or out-of-state participation, that's only 7 months old. Okay. $102,000 cap. Basically what that is you can put up to, the account cannot exceed $100,000. And the reason it's 102 is that you can also own $2,000 more of assets that you otherwise didn't, that won't disqualify you. And so that's the reason for this $102,000. If it gets up close to $102,000, you stop contributing and you start spending. And there's no impact on Medicaid eligibility. It's not counted as income. However, here's the bottom line. This is how it differs from a third-party SNT. On the death of the beneficiary, you have to repay Medicaid assistance. So if prior to death, prior to passing of the person with disabilities, not your death, but the child's, if that person incurs expenses that are paid for by this public program, the public program can claw back or take out of whatever the balance is before it's ultimately distributed to other beneficiaries.
Thank you. When you say Medicaid assistance, my son receives med waiver. After he's 18, he would have Medicaid. Is that meaning medical bills that they've paid?
It's exactly what it means.
Wow.
Yeah, no, it can take the account away.
Yeah.
It can take the account away.
I would think so.
That's the downside, but I'll tell you, it's the downside of a first party SNT as well. If there are medical expenses, third-party SNTs don't have the same status. As far back as they can, as far back as they need to go in order to take all the money out. But remember, it's only $100,000. It's not $1 million. So if you had $1 million worth of expenses, they obviously can't take more than what's in the account. Or what you do is you spend down the account, and I don't know whether you can spend it down, and I don't know whether we can predict ultimately what's going to be left, because when you spend it, it has to be spent on the beneficiary or for that beneficiary's needs. We got 10 minutes. Let's have a question back here.
So can the money you've placed in the ABLE account be later transferred into a special needs trust?
Well, there wouldn't be a reason for that, because what this is a low-cost alternative to an SNT and the SNT that it would go into would not be a third party that's set up as part of the parent's estate plan. It'd be a first party SNT that's set up by the child himself or herself. And that trust has the same bottom line: on the death of beneficiary, must repay Medicaid assistance. So there wouldn't be any value in order to get rid of that problem. What I would want you to see conceptually is that it's like an SNT, except that it doesn't cost you any money to maintain. It's just an account that grows on its own like an education account.
I guess my only concern, not that I have $102,000 to just throw in there, but
well, you would only do it at like $5,000 a year.
But that doesn't seem like enough. Like, by the time I die, I need to have a lot more than $102,000 put away for my son to take care of him for the rest of his life. Right.
So you're like everyone else, and there's never really enough money to anticipate the needs. The question is, how can you lessen or relieve the burden on those who are ultimately going to be responsible for that person's care? And it's not just housing; it's everything else that we need to survive. And so this could be something that is created in lieu of a first-party SNT during the child's life. And then in your own estate plan, you would establish a third-party SNT and say, okay, I've got this estate, I have 3 kids, I want to divide it in whatever percentages. In my instance, I have uneven percentages because I want my other kids to have more than my child with disabilities, and I hope I'm guessing right, I don't know. But let's assume that you divide it equally, 1/3, 1/3, 1/3. The 1/3 would go into a third-party SNT. It's part of your estate plan, wouldn't be distributed to the child, wouldn't be tapped to repay Medicaid assistance, right? Because that's not a feature of it. And that would just go on and on and on until that child passes, and then when he or she passes, whatever's left doesn't go to the government, it goes to the other 2 kids, or to the other 2 kids' kids if they predecease the person with disabilities. So I see it as an adjunct, and I see it as a really good option instead of setting up an SNT. I've set up a few SNTs. I set up one just recently because there's a provision in which you can do this, a person needed to go into a facility, long-term care facility, wanted to qualify for Medicaid, transferred her estate to the person who is her child, who's an adult with disabilities, not PMS, but something else. And so the transfer was made, we set up first-party SNT, that qualified so that this person has the mother's money, and the mother was able to get into a facility that took Medicaid. You had a question?
At what point did you say they could take back the medical?
After the beneficiary dies. Right. Oops, okay.
Rick, we have a couple questions. One in the back was, can you try to buy a program online and do it yourself?
Oh, that is a great question. You know, I was thinking about that, and it's nowhere on this slide. So I'm going to answer it by giving you this example. People come into my office all the time, and they say, not all the time, sometimes, and they say, I went to LegalZoom, and I pulled this program, and it cost me $29, and then I don't know what to do next. And not only that, you have to pay another $29 in order to get part 2. And then there's part 3, and then there's part 4, and they're looking at the language, and nobody understands it. And they say, what should you do? And I say, well, we're going to start by throwing it out. I think that it serves a purpose, but I don't think it serves a purpose when you're dealing with something that has such dramatic consequences if you don't get it right. ABLE, you can go to a financial services entity. You can go to Dean Witter or Merrill Lynch, and they will set one up for you. SNTs, you need to go to an attorney because they are so complex, and you have got to have the right language in order to protect the assets. And so I'm not a person who says, oh God, lawyers are the only ones that can do these things. But this is not regular stuff. This is hard stuff. And there is an alternative if you don't need or want to do an SNT. But if you're going to do an estate plan that includes an SNT, you need to see a lawyer. Remember I started? You need to see a lawyer with estate planning experience, but more importantly, a lawyer with special needs trust experience, because there aren't a lot of those out there. They're out there, but it's not sort of the run of the mill. Okay. Was there another question, Veronica?
There's a couple. Do you have 5 minutes? Just,
okay.
Actually, these are my questions, so I apologize. In the case of a divorce, when the dad is paying child support, that support is considered the child's income?
No.
Okay, good, perfect. Okay.
First of all, child support is support for the child. Just so happens that the other part of my firm's practice is family law. We do a lot of that. It is not income to the recipient. It is not deductible by the payor. And it does not go directly to the child. And a lot of people have trouble with that because the person who receives the child support is not obligated to spend it either directly or indirectly on the child.
So the government can't access those funds?
It's not child's income, no.
Okay. And then creating, let's see, using a special needs planner in order to come up with a whole plan, and then he has an attorney that he works with to make sure everything's put in the correct verbiage.
I get it. I think your question is, do you go to a financial planner who would then engage an attorney to draft a plan? I mean, I work with financial planners. I'm not a financial planner, but for the most part, people come in my office and they say, well, I need a will. And I say, well, what's your situation? Do you own a house? No, you don't need a will. You need a trust. And so you don't need somebody with financial planning experience in order to do that. You just need to go see a lawyer who's drafted one of these things before.
This is a company in Dallas that actually helps you get the most benefits out of the government benefits. Mm-hmm. So they charge for their service, and then they kind of bundle it together and work with an attorney. And they've told me that they can kind of work with you throughout the process, make sure you've got everything, you're getting the benefits, but they want to charge with legal fees probably about $5,000 for everything. I don't know if that's kind of standard.
That's a lot of money, even in California.
Okay.
Let me say that differently. There isn't a one shoe, fits all, or one size fits all. It depends upon the complexity of the entire plan, and that depends upon things that are in addition to the complexities that we have with our children and the need for SNTs. It's not unusual for $5,000 to be spent, but I can tell you throughout at least my experience and my somewhat limited knowledge base, that's at the upper end of estate planning for ordinary families.
What should people kind of expect? I know every area's different market, but, what's a kind of a normal of what people should expect to pay for?
2 to 3, 1,500 to 3. For an entire plan. A trust is only one document. I mean, I've got 20 documents in my plans. Okay, some of which we're going to talk about next hour. Housing crisis, Section 8 housing vouchers. I talked to you about that. The wait list for Section 8 housing is as long as my arm. The Section 8 is needs-based, which obviously our kids will qualify for at the age of 18, and we've got these long waiting lists. Secondly, group homes. Again, I attended a session this morning where 5 moms were talking about placing their children, and a couple of them placed them in group homes, and it had nothing to do with the legalities of it, but my point is that there is assistance available from state to state to pay for 24-hour care, as well as for the rent to or in group homes. And obviously, what we're all doing is we're providing housing ourselves, and we don't get paid for it. But we've got private housing, and that it falls on the families. 3 decades ago, these kids would be in institutions. We don't have them anymore. Institutions are gone. We are now the gatekeepers. Our houses are the places where people live. And so whether it's in your own home and you can't receive rent you can't be paid, I should say, for that other than IHSS that I talked about, or you can have your child go somewhere else, and for the most part, I mean, it's horribly expensive when you think about it to have 24/7 care, given the cost of employees. But again, state to state, I'm going to be talking about self-determination, which is coming in the next hour. That's going to assist dramatically. And so there's our house, by the way. It's a tent. We can afford to live in a tent. No, just kidding. So the bottom line for all of this, I know I'm out of time, is find a good lawyer. Communicate with your family and those in your child's circle of support. That's that memorandum of intent. You don't just draft it and put it away. You talk to people about what it is that you expect, what you want, what your desires are, what the needs of the child are. And then finally, plan today for when you are gone, because we're going to assume that you're going to go before your child. All right, I think I'm out of time. Thanks very much, everybody.